Will customary title give its iwi holders an effective veto?
The member should indicate which minister is questioned.
My apologies, Mr Speaker, to the Attorney-General. And my question asks, will customary title give its iwi holders an effective veto over coastal activities such as aquaculture, building or extending a building over foreshore or seabed, and undertaking any excavation of the foreshore and seabed, given that customary title grants title holders, quote, the right to permit activities that need a coastal permit or resource consent, close quote.
Mr Speaker, I'm ready. Iwi with a customary title will have the ability to permit specified activities in their area of title, subject to guarantees protecting public access and existing use rights. This is a basic property right. This government believes in property rights.
Supplementary to the Attorney-General. How many years does he estimate it will take the Crown, the courts and iwi to determine the number and extent of customary titles in the foreshore and seabed of New Zealand? 10 years, 20 years, or perhaps 100 years?
The Honourable Chris Finlayson.
As long as it takes to get a just result. You don't determine the quality of justice by the speed with which things are done.
David Garrett.
Is he able to assure the people of New Zealand that customary title will not be granted to iwi by the Crown or the courts over any part of the following: 90 Mile Beach, Raglan Beach, Wainui Beach, Ohope Beach or Piha Beach?
Honourable Chris Finlayson.
I don't think it would be helpful to get down to that level of detail in answer to a parliamentary question. These are fact-specific matters, and I am going to deal with the matter in that way.
Mr Speaker.
Point of order. Point of order, David Garrett.
Mr Speaker, my question was very deliberately precise and asked the Attorney-General if he could give an assurance regarding customary title over certain very discrete identified pieces of New Zealand coastland, and what we got was a waffle answer.
Well, ordered. No. I believe the answer from the Minister was that he wouldn't give that assurance. Supplementary question, the Honourable David Parker.
Thank you, Mr Speaker. To the Attorney-General, how much more of the foreshore and seabed does the Attorney-General expect will be subject to customary titles as a consequence of the change to the threshold test which applies to territorial customary rights? That change being to no longer require continuous ownership of contiguous land while still requiring...
Order. I apologise to the member asking his question. I'll invite him to start again. It's a serious question, and I could not hear with the unnecessary interjection across the House.
Thank you, Mr Speaker.
The Honourable David Parker.
How much more of the foreshore and seabed does the Attorney-General expect will be subject to customary titles as a consequence of the change to the threshold test, which currently applies to territorial customary rights? That change being to no longer require continuous ownership of contiguous land while still requiring continuous exclusive control of the foreshore and seabed concerned.
Honourable Chris Finlayson.
With respect, that's a very good question, and it's an important question, and I believe, in answer to the member, that we're not talking about very much at all. The overarching requirement is the exclusive possession test. This becomes a factor, not a requirement, but at the end of the day, I do not believe it is going to result in very much more foreshore and seabed being the subject of customary title. But it's a good question.
Rahui Katanei.
Thank you, Mr Speaker. To the Attorney-General, how will the tests for customary title accommodate the special circumstances of iwi and hapu who have been affected by raupatu, fraudulent land transactions or other breaches of the treaty?
The Honourable Chris Finlayson.
The tests for customary title don't prevent an iwi which has suffered raupatu or other forms of land loss from seeking customary title, and they can do that either by negotiation or by application to the court. They may not be able to satisfy the test, but this is a jurisdictional question. We're not in the business of preventing them at least being able to make the claim.
Rahui Katane.
Thank you, Mr. Speaker. How will customary title translate into development, occupation and usage rights for hapu and iwi, quote, as though they were the owners of the land, unquote?
Honourable Chris Finlayson.
Within areas that have a customary title, iwi are going to have the same permission right as other property owners. They'll also have development rights and will also own the minerals which were confiscated by the 2004 Act, and by that obviously I exclude gold, uranium, silver and petroleum, as I indicated in an answer yesterday.
And that brings to a close questions for oral answer. Would some honourable member care to move that the House